So first of all, I'd just like to thank FLAC, particularly Nolene and Paul. MABS and FLAC have worked together for a long time now for people in debt and people struggling to cope, particularly now since the recession. MABS recently was given the task of the approved intermediaries, and as Nolene said, I am somewhat responsible for rolling out that service throughout MABS nationally. It is an exciting time, but it's also a very challenging time for MABS. It's a very new service, it's a very new area, and the interest is huge in this. Of course, all of the insolvency arrangements that are being discussed today are instruments of last resort. And I think it would be remiss of me, certainly on behalf of MABS, if I weren't to say that it's so important for debtors to engage with their creditors, to engage with their budgeting, to have proper money management skills, and to do so at an early stage. Without further ado, though, of course, I continue with the task at hand. So, debt relief notices, what are they and how do I apply for one? Again, this is very much from a practitioner basis. And then if there are people who may wish to go ahead, the process of applying. I wouldn't be a solicitor if I didn't have a disclaimer up straight away. This is not intended to be training, it is for information purposes only, of course. So the outline, what's a debt relief notice? How will I know if I'm eligible? And I'll go through some detail in relation to the eligibility criteria because it can be quite complex. What are the effects of a debt relief notice? And then, of course, how do I apply for one? So, debt relief notices, what are they? As Lorcan said, they're a solution for a certain category of people. They're not for everybody. They won't be the solution for the majority of people in debt. They're provided for by the Personal Insolvency Act, of course. They're for debtors with quite a low level of debt, low levels of assets, and low net disposable income. They're subject to a 3-year supervision period with a write-off at the end, and they're applied for through an approved intermediary. At the moment, MABS is the only organisation supplying approved intermediaries across Ireland, or will be the only. So the 3 headline criteria in relation to eligibility for debt relief notice are debt levels, asset levels, and a net disposable income. There's then what I call kind of the catch-all, which is the other. They require a little more discussion by the practitioner with the debtor to determine the eligibility on those bases. So qualifying debt. It's qualifying debt of 20,000 or less, and that includes things like personal loans, credit cards, credit union loans. It's a non-exhaustive list set out in the legislation. They don't include, as the name might suggest, excluded debts, and we'll go into that in a little more detail, and they may include excludable debts on the working of a process by the approved intermediary. Excluded debts then, these are domestic support orders, so family maintenance orders, things like that, debts arising from personal injury or wrongful death claims, loans obtained through fraud and embezzlement, court fines for criminal offences, or court orders under the Proceeds of Crime Act. And those excluded debts and the excludable debts are the same across the board for whatever arrangement comes under the insolvency legislation, so the DSAs and the PIAs. The excludable debts then, they may be included, as I said already. So if a debtor wishes to include one of these debts here, they must request their approved intermediary to contact their creditor on their behalf and seek the creditor's consent to have the debt included in their application. If the creditor consents, then obviously it can be included, and if the creditor doesn't come back within 21 days of the letter, then it may be included as a permitted debt as well. But just, I suppose, for practitioners to be aware that if it is included, it's going to obviously have an effect on the threshold of the 20,000 and also on the calculation of the net disposable income. And we'll have a look at that now in a minute as well. So excludable debts are things like taxes, duties, levies or other similar charges owed to the state, local government charges, the household charge, local authority rates, debts due under the Nursing Home Support Scheme, management service charges so owed to management companies, and debts due under the Social Welfare Consolidation Act. So just, I suppose, because they're new categories of debts, just to bring through a very brief example. You've got John, he has 32 grand's worth of debt. So on the face of it, very high level, he's over the threshold. However, his debt comprises of 12,500 to credit card companies, 4,500 to legal money lenders, 9 to the revenue commissioners, and 6 to maintenance domestic order. So what are his qualifying debts? Obviously the credit card debt, the legal moneylender. The Revenue Commissioner then is of course an excludable debt, but of course if John were to include it, he'd be over the threshold. And then there's the 6,000 that's owed in respect of maintenance that will never be included in an application for DRN. The asset threshold then, and certainly at the time the heads of bill came out and throughout all of last year there was a lot made of the €400. Now, it's still not a very high level of asset, however there are some exceptions to that. There's the car of €2,000 or less, one item of jewellery up to the value of €750, the household goods, tools of the trade up to €6,000, books or equipment needed for primary, secondary education doesn't have a threshold, and interest in a pension. Now, what I would say in relation to cars and jewellery, again, as with everything in the legislation, there's a nuance to it. For the car to be accepted, even if it is below the threshold of €2,000 or less, the debtor must need it, and it mustn't be financed by way of a loan that's included in the DRN application. So not just a secured debt, but a loan that has financed the purchase of that vehicle. Similarly, the item of jewellery can't have been financed by way of a debt that's included in the application. The interest in a pension is an accepted asset. However, if the debtor was due a payment under, so a lump sum or an income, either at the date of the application or within 6 months of it, it will be treated as an asset or an income. So, net disposable income then. Again, a lot was made of the €60 a month, and it is subject to a statutory calculation. It's set out in section 26(5). So there's the income of whatever nature, excluding child benefit, less the reasonable living expenses, and there's the cover sheet for the ISI, less tax, PRSI, universal social charges and any levies, less payments to excluded debts, and less payments to excludable debts. Again, harking back to what I was saying around debts and the fact that excludable debts have an impact on the net disposable income calculation. So just again to kind of labour that point a little, we have Jane. She's a shop assistant. She earns $1,200 a month after tax. She lives alone. She has no car. She has a room in a house. She pays €200 a month rent. According to the ISI guidelines, her RLEs, or her reasonable living expenses, are €900.08 plus reasonable housing costs. She has a debt to the Department of Social Protection and pays €100 a month to this. So just to have a look at what would happen as to whether or not that debt would be included or should remain excluded. If the debt isn't included, she'll have a net disposable income far below the €60 threshold per month. If it is included, however, because she won't be paying that €100 a month, she'll have an income in excess of the €60. So again, for a practitioner, it's something to consider as you're going through the eligibility criteria with a debtor. The other criteria then, of course, the domiciliary condition, so the debtor must be domiciled within the state or within 12 months of the application, be ordinarily resident or have a place of business within the state. The debtor mustn't have any likelihood of being solvent within the next 3 years, and section 26(7) sets out some criteria for an approved intermediary to consider when looking at the debtor's solvency. Preferences and dispositions then within the 2 years preceding the application. So if a debtor gave a preference to a creditor, made a lump sum that had the impact of substantially reducing the amount available for other creditors, then they would have given a preference to that creditor. Similarly, for dispositions, if a debtor enters into a transaction at an undervalue within 2 years that materially contributed to their insolvency position, then they also will be excluded. When were the debts taken out? Again, an anti-avoidance provision in the legislation states that if 25% or more of the debts were taken out within the last 6 months, and that's 6 months preceding the application date, then the debtor won't be eligible at that time. Other arrangements under the Act, obviously this won't kick in for a while, but if the debtor had a protective certificate in place in the last 12 months, or had a debt settlement arrangement or a personal solvency arrangement in the last 5 years, they won't be eligible at this time. And similarly, if they're engaged in bankruptcy proceedings or if they've been discharged from bankruptcy in the last 5 years, they won't be eligible at this time. Effects and consequences of a debt relief notice then. For the debtor, it's a 3-year supervision period and it's quite stringent. They do, however, get protection from those creditors that are subject to the debt relief notice. If there's a material change in circumstances, they need to contact the ISI and inform them of that. If there's an increase in their income of €400 or more per month, they must contact the ISI and pay over half of that amount. The ISI will then distribute that on a pro rata basis to the creditors. Similarly, if they get a lump sum or a gift worth €500 or more, they must contact the ISI, pay over half for distribution to their creditors. There's also a disclosure requirement if the debtor wishes to borrow more than €650. They must disclose the fact that they have a debt relief notice. Now, obviously, because they're going to be on a public register, that information is going to be available anyway. On the creditor side, then, of course, the creditor can start or continue legal proceedings in relation to the debt and in relation to that specified debtor. They can't take any debt collection action. They can't enforce a judgment in relation to that debt against that debtor. They can't recover goods. They can't request payment in relation to that debt. They can't terminate an agreement by virtue of the fact that the debtor is insolvent or has a debt relief notice in effect. But they do, however, have a right to object. Now, of course, one thing I would say is in relation to the prohibitions on creditors, they are only in relation to the specified debt and only in relation to the specified debtor. So if, for example, there's a joint borrower or there's a guarantor, the creditor can still enforce against them. Offences then, I suppose I'd be remiss not to bring those in. False representation, of course. Full disclosure is absolutely paramount, as it is in MABS work anyway, but certainly under the insolvency legislation it certainly is. Failure to comply with obligations under a debt relief notice, concealing or falsifying documentation, fraudulently disposing of property, obtaining credit in excess of the thresholds without disclosing the debt relief notice, or acting as an authorised intermediary or a PIP without the relevant authorisation or licensing. They are subject on summary indictment to a fine of no more than €5,000 and or 12 months imprisonment, or on indictment to a fine of €100,000 maximum and or 5 years imprisonment. So, if that hasn't put everybody off, how do I apply for it? You apply through an approved intermediary, and as I have already said, MABS will be the only organisation at present who will have this service available. You'll provide documents to support the application before the first meeting so the approved intermediary can review the case. There'll be a meeting with the approved intermediary to discuss the options, the pros, the cons, the consequences in the particular case. If applicable, the approved intermediary will request the consent of the excludable creditors. You'll then come back for a second meeting, go through the eligibility criteria at the date of the application, complete a prescribed financial statement and swear an affidavit that that prescribed financial statement, PFS, is true and accurate. The approved intermediary will then process the application and send it to the insolvency service. The ISI will review it and send it to the circuit court, and the circuit court will either approve it or reject it. And that's just, I suppose, something for your wall. So what happens next then? If it's successful, the debtor is subject to the supervision period, as I've said, of 3 years. The approved intermediary will send the debtor's file into the ISI and will have no more interaction in relation to that case. If the debtor has further queries, they must contact the ISI. If the debtor keeps the terms of the debt relief notice, any outstanding balance at the end of the supervision period will be written off, and the details will be removed from the register within 3 months of it ending. So I suppose, in summary, it's an optional last resort. It isn't suitable for everybody. It's applied for through an approved intermediary. The debtor must have quite low levels of qualifying debt, assets and net disposable income. There are some very strict eligibility criteria, as we've seen. There's a 3-year supervision period with debtor and creditor obligations, but there is a discharge from debt at the end. Thank you very much.